Martin Bienenstock heads the Business Solutions and Government Department at Dewey and LeBoeuf here in New York. He helped GM prepare for its recent reorganization, and he represented Chrysler Financial in Chrysler's recent bankruptcy filing. He's here to help us sort out what may happen next at CIT. Now, in both of those cases, Martin, you had the government on the side of the companies going into bankruptcy. In this case, you have the government at least staying out of it, neutral if not against. So is there much hope for CIT if it has to file for bankruptcy?
The hope recedes, but there is hope. There's nothing like cash to solve a problem. The problem CIT has is that when the debt spiral sets in, the rumors, the customers leaving, employees worried, lenders not wanting to lend new money, the problem magnifies itself, so they have a very short window to come up with cash.
Now, they do have until, say, the end of the month before they have to start rolling over some debt, but in this kind of case, is it better sooner to go into bankruptcy, to go into court to seek protection than later?
Well, I think what Lehman demonstrated, where its CEO says they lost $50 to $78 billion by prematurely filing, that CIT may not necessarily have its best move as filing quickly. It's got to decide how it can best obtain a soft landing for its creditors.
Now, it could file Chapter 11, and not, unlike the Lehman Brothers broker-dealer, they don't have to file Chapter 7, right?
No, they don't. They can file Chapter 11, and of course the banks are not eligible for either chapter.
And no government assistance coming. If they file Chapter 11, do you think that there is a good chance they could come out? Or at this point, is reorganization beyond the question? It's really a question of money.
I think they're not going to come out as CIT, most likely. And the Chapter 11 will be a type of Chapter 11 liquidation, but it might be a liquidation as a going concern. They might sell off their various divisions as going concerns to stronger players.
Well, what's the obligation of the court in this case, since there aren't really assets as such?
The obligation, I think, in this case would be to process it quickly. What would hurt our economy the most and the value the most is if CIT's customers, borrowers who need money, can't get money from CIT, but also can't get money from others because CIT has a lien against their assets. So the processing of moving the borrowers from CIT to new lenders has to be quick, or lots of other companies will fail and there will be a domino effect.
Well, you raise an interesting question, because in Lehman, a lot of cash was frozen when they filed. Would that happen in this case, and what happens to the borrowers? Do they have to repay immediately? How does that work?
Now, the borrower's obligation to repay CIT would not be accelerated, but the borrowers need money. And in most cases, they pledge their assets to CIT to secure what they borrowed from CIT. So before they can borrow from another lender, they have to get CIT to release the lien on their assets. That's where CIT's creditors will say, we don't want to release any liens, but the borrowers are going to need that to go on in business.
Yeah, hence the need for speed. They got $2.3 billion in TARP money, taxpayer funds. If they do end up liquidating, where does the taxpayer stand in the roster of creditors?
Well, the TARP statute required the government to get the best position available. So probably the TARP money at CIT has a lien junior to existing bank liens, but senior to all its unsecured credit.
So we might not lose everything, but lose part of it?
That's right.
All right. Thank you very much. Martin Bienenstock of Dewey and LeBoeuf here in New York.